Hello, this is Rex Crandell, and today we're going to be talking about advanced healthcare directives. The form's also known as a durable power of attorney for healthcare. It has multiple names. Some people on the end of life decisions part of the form refer to it as a living will. I don't particularly like that word, but first of all, it's authorized by the state statute 4701 that allows a person to grant authority to exercise your rights in terms of utilizing healthcare facilities, treatment, various types of care items. The form needs to be filled out in advance. It's normally done with an estate plan. We do what's called a comprehensive estate plan with trust, pour over will, durable power of attorney for asset management, and this advanced healthcare directive in one package we call comprehensive estate plan. And it's an important component. Why is it important? Well, let's say hypothetically you're driving and you get in a car accident and you lose the ability to speak. Let's say you have a head injury. Now you're rushed to the emergency room and the doctors can't talk with you. You don't know that, let's say you're unconscious, and the doctors don't know what kind of treatment to give you. So they will give you extraordinary treatment. And but you're going to need to have someone make medical decisions for you. It's contrary to the law for the doctors to make the medical decisions for someone or to be appointed as an agent. And so basically what we're doing here is granting the authority for an agent to make your medical decisions. And you have the right to do that, and you grant all your rights or whichever rights you want to grant for consent for types of care, treatment, discharge or hire doctors or hospitals, approve diagnostic report, surgery, anything that would come up in a medical environment, to utilize or withhold artificial nutrition, hydration, and cardiopulmonary resuscitation. And also you could include organ donation. The form itself needs to be either signed by two witnesses or signed in front of a notary public. We frequently will use the notary public method because we feel it gives better assurance for the healthcare providers. The two witnesses cannot, at least one of the witnesses cannot be a relative of the person granting the agency for healthcare. So who would be a good person? Somebody who's reliable, competent, communicates well. Maybe they have a medical background, although that's not required. Being rational is. And we have our clients appoint an agent. And if that agent doesn't, is unable or unwilling to do the task, then we also alternate or nominate an alternate agent and then a third alternate agent so that we're never left without an agent. And in terms of granting authority, any authority you want or limit it in any manner that you want. And then you'll have to decide on when the durable power of attorney for healthcare is effective. We always set it up to be effective on signature. You can have it set up on when you become incapacitated, but that's not required. If you appoint an agent under the Advanced Healthcare Directive, you still have the right to make your own medical decisions. Identify what your agent gets in terms of instructions for organ donation after your death. And also, this form nominates a conservator, and it is the same people that we have, the first, second, third agent. If you need to have a conservatorship in the court for a conservatorship of the person, then this document tells the court the people that you want to have managing over your assets and conservatorship of the person. You also can include end-of-life decisions to prolong or not prolong life, instructions on pain. I want to have pain relief, even if it might hasten my death. Other wishes that are frequently included in Advanced Healthcare Directive are information relating to religious ceremonies, burial, cremation. And in terms of organ donation, you can list all the organs. You can say, donate my body to science, any organs that are needed. Most of my clients say all my organs are worn out anyway. Nobody would want them, but that's not exactly true. So organ donation is just a part of the plan, and do it or don't do it, it's your choice. The form also has a place to indicate a primary physician. Who's your main doctor? We usually leave that blank because we want the agent to make the decision, and we're finding a lot of doctors lately have been retiring, so we didn't want to be bound by one agency or one doctor or one health care plan. We're normally, but leave it to the agent to decide, but it is your choice. So you need it signed by 2 witnesses or before a notary. We always use the notary, and one of the witnesses must be a non-relative, as I mentioned. And if the person creating the Advanced Healthcare Directive is currently a patient in a skilled nursing facility that provides supportive care to patient, skilled nursing availability, then that person also needs to have this form signed by what's called a patient ombudsman or a patient advocate. When someone's in a skilled nursing facility, this patient ombudsman has quite a bit of authority supervising the care facilities. And that's the reason why that person gets or must sign the form. Overall, Advanced Healthcare Directive is an important part of an estate plan. Nobody that I'm aware of wants to become incapacitated, but it might happen instantly. And in that case, you still want to have your wishes and your desires taken care of in terms of being followed and what you want to happen in your incapacity or after death. So at this point, I would advise everyone to have an Advanced Healthcare Directive. If you have any questions, you can contact our office.